Swapnil, I'm really sorry. We are putting out this breaking news for our viewers that even while observations are coming out of the Apex Court, the Chief Justice of India has dissented. This is a big development that has come out. So this is the 3:2 ratio judgment that has come out of the Supreme Court of the country, with the Chief Justice of the country, UU Lalit, also going ahead and dissenting with the arguments placed. Let me take this across to my colleague Anusha to break it down for us. Yes, Anusha.
Well, Griha, the judgment is there. 3 judges on the bench have already given their stamp of approval to the EWS quota. So as far as the 103rd Amendment to the Indian Constitution is concerned, that's good in law. That position doesn't change. But I see this as a student of law that dissents have a very important place in jurisprudence. The fact that it's none other than the Chief Justice of India who presided over the bench has dissented along with Justice Ravindra Bhatt, it's going to arouse some academic and judicial interest in terms of the reasons that they have cited. That being said, EWS quota, good in law, not violative of the basic structure, a victory for the government which had brought in this policy, but all eyes on what precisely the reasons are why Chief Justice of India UU Lalit thinks that the 103rd Amendment to the Indian Constitution is actually violative of the basic structure, because that is the sole basis on which the Supreme Court or any judge on the bench, of the Constitution bench can actually say that 103rd Amendment is bad in law.
Yes.
So the argument coming in from the Chief Justice of India is going to be very interesting, who's set to retire tomorrow.
Absolutely. Anusha, let me take this across to my colleague Ananya, who's also with us on the broadcast, who's brought us this breaking news input. Ananya, very important development once again coming in. The argument that possibly has come to light, one of the other dissenting judges, Justice Bhatt, also talked about the breaching of the 50% cap. Do you think UU Lalit is also going ahead with the same argument? And also the fact that giving more quota to SC/STs above and beyond what they already have. Was that also part of the discussion?
Well, all of this was a part of the discussion, but at the heart of it, at the biggest part of it, it's a 3:2 judgment. It's a judgment wherein 3 judges have concurred and said that there should be the 103rd Amendment to the Constitution of India is completely valid in law, while 2 judges, Chief Justice of India, Justice Uday Umesh Lalit and Justice S. Ravindra Bhatt, has actually dissented with this particular opinion and said that the 103rd Amendment of the Constitution of India is actually invalid and unconstitutional because it excludes the SC/STs and OBCs, and that's the big piece of breaking news that is coming out of the Supreme Court. This was a 5 judges Constitution bench which has just now pronounced its verdict, but
definitely, though it's a 3:2 judgment, though there are 2 dissenting judges on here on, and as Anusha was pointing out, dissent has a very, very important point to play when it comes to academia, when it comes to debate. But at the same point of time, it's a big, big win for the central government. It's a big, big win for the 103rd Amendment that's been brought in. And it's not only that, but also a big, big win for the EWS category of the upper caste, who would continue to get this reservation of 10%. In fact, the 3 judges who have concurred into this opinion, a very important point came up from Justice Bela M. Trivedi, that the reservation system, after 7 decades of independence, after 75 years of independence, has to be relooked into. And that's the very, very important point that is coming from Justice Bela M. Trivedi, who has concurred with the opinion of other 2 judges. In fact, there is a need that is there for the reservation to actually be relooked, and the 103rd Amendment of the Constitution of India has been upheld by the Supreme Court in a 3:2 ratio, where 2 judges, the Chief Justice of India, Uday Umesh Lalit, and Justice S. Ravindra Bhatt, dissenting, while the other 3 judges concurring to this opinion. Studios.
Right, Ananya, thank you so much. Let me take this across back to my guests who continue to be with us on the broadcast. Swapnil, I'll come back to you. You were making that point, but let me add to it now that we have come out of the Supreme Court, and this is what is happening. 3:2 judgment with 2 dissenting judges, one of them the Chief Justice of India, Justice UU Lalit. He, in fact, while this entire verdict was being looked at, had also observed that economic basis cannot be a permanent criteria. And probably on the basis of that also, the dissent has been underlined.
Yes, in fact, Anusha is absolutely right there that the dissenting judges do matter a lot. Rather, their judgments do matter a lot. They sometimes pave way for a majority judgment in the future, where things could be different, circumstances could be different. 20 years down the road, maybe the dissent would be viewed more as a majoritarian view and quoted, and this whole thing would be upturned on its head. So, the economic sections do not. For a longest time, I think they do matter in some form. There, with due respect, I disagree with his lordship, and I would be interested to know his dissent in more in detail as to apart from the precedents that he may quote. But I disagree with him there because today the current climate is such that there are people who are extremely poor, there are people who are below the poverty line. There are people, even in the forward classes, even the Brahmins or Kshatriyas, who do not have that kind of money to go to a good college or a good university, for that matter. So they will require that particular reservation to boost them up, to bring them along with, to see the, simply put metaphorically, the light of the day or see the dawn the way you and I do. So the thing is that, to pave way now by dissenting, say that 20 years down the road, maybe my dissent could be, taken as a majoritarian view, and that is possibly there in the minds of the Chief Justice and also Justice Ravindra Bhatt. And this is usually happens in the Supreme Court. They tend to look about 30, 40 years down the road and say that, look, if there are three majoritarian views, which they obviously would have been aware of, let me take a dissenting view, even if I may intrinsically agree with her majoritarian view. But let me pave this way now to say that, look, this is also to be there and looked at by the government in question tomorrow, or say by even the policy framers, or even by the policy makers, or even by private unaided institutions, because that is where the crux lies. Because as a private unaided institution, if I'm super rich, I do not want any government to tell me what I am supposed to do in my institution. I'll say, to hell with all the reservations, I don't care. Nobody is there to prescribe some 10% to me. I don't give a damn about it. I'm already have given meritorious scholarships based on the basis of merit to even poor people. So I'm doing my job. So the thing is that this is where the dissent has its value. But to totally dispense with the economic aspect is something which I do not think that Baba Sahib Ambedkar would have agreed with, or today even most of the senior advocates would agree with this view today. And, maybe one-on-one justice, Lalit could enlighten us. As we often have post-retirements, we often have these one-on-one talks with them, and they go in this litany of judgments, and the way they look at the Constitution and the way they see that into the future, and it's a great exercise. It's great to see, because you have the most brilliant minds occupying the bench today in the Supreme Court, in the apex court. So basically, you're looking at people who are visionaries. So it's great opportunity for us also, even after 28 years of practice, where even we can tell them a few things, with due respect, I disagree or I differ. But this is something which I would really be happy to read, both Mr. Bhatt, because their dissent comes out very strongly, especially Justice Bhatt, because I could hear him. He is coming out very strongly against it. So I would want to know, even if I vehemently disagree with him, but I would want to know what his reasoning is behind totally dispensing with the 103rd Amendment.
So Swapnil, while you mentioned that dissenting judge, Justice Bhatt, he also mentions that the breaching of the 50% criteria would lead to the formation of compartment classes. And that's his basic idea. And also challenging the exclusion of SC, ST and OBCs from this EWS criteria is something that he said is not constitutionally viable, an option.
Well, that's, he's what he's trying to do is he's trying to compare the economic sections with the OBC quota and all of those things. That this is where my fundamental difference lies. Let the Mandal Commission judgment, Indira Sawhney, lie alone. Do not bring that into play. That was a separate judgment. It was by 9 judges. You say that, somewhere there seems to be an overlap. There seems to be more reservations. Maybe that is your reservation against the reservations where you're thinking that merit is going to take a backseat. The short answer to that is no. The simple way of looking at it is that if there are certain poor people, I want to make people who will say that, look, I don't even have an income tax return because my income for the whole year is below 4 lakhs or 5 lakhs of rupees. How do I go to a good college, or how do I go to a good university? And that is simpliciter. The state is trying to pave way for that, because there was no need to mention the unaided and the aided part both in that 103rd Amendment. Why do you take that particular? They are looking at education, basically. That is the fundamental, because the right to education is a fundamental right. And that is where the 103rd Amendment is trying to bring in more people, make people more educated, because that is the root and the base for progress. So if Justice Lalit were to look at it this way, then maybe he would have arrived at a different conclusion. But I think I think he has his views set on a certain way, and he's entitled to that.